So let me start, first of all, by expressing my thanks to Isaac and the Center for Intellectual Property and Information Technology Law for having organized this particular workshop and for inviting me to come and speak. I'd like to congratulate Strathmore University Law School on the work that it is doing to build what is going to be a very prestigious law school that I'm sure will contribute a lot to the legal sector in this country. The topic for today, to patent or not to patent, and how we can protect intellectual property in ICT, is a very important and topical one. We are aware of all the work that is being done by local developers in this particular area, and questions have arisen as to how their interests can best be protected. As you know, the Kenya Industrial Property Institute is the body corporate established by the government under the Industrial Property Act to administer matters of intellectual or industrial property, I should say, because the two other branches of intellectual property, that is copyrights and plant varieties, are taken care of by two other bodies. And specifically, if we look at KIPI, what is our role? Just so that you know, as I speak here, what exactly it is that KIPI does and does not do. First of all, we consider applications for industrial property rights. That means that we examine applications for and grant industrial property rights in the form of patents for inventions, utility models, industrial designs for the aesthetic elements of products, and trade and service marks for goods and services. We also provide industrial property information to the public, and we promote inventiveness and innovativeness in Kenya. So our primary role is really the administrative one, where we receive and process industrial property rights for various classes of works. If I just share some few statistics with you, for last year, if we look at patents in particular, the 2011-2012 year, we received 231 patent applications, of which 77 were in the biochemistry area, 58 were mechanical, 46 were electrical, 29 chemical, and 21 natural science. We also received 110 industrial design applications and 57 utility model applications. If you were to dig further into those figures, you'd realize that the majority of those applications are actually foreign applicants, a good number of them coming from pharmaceutical companies, as well as some IT companies. Then, over that same period, we granted 70 patents, 25 in biochemistry, 22 in chemical, 10 in mechanical, 9 for natural science, 4 for electrical engineering. We also granted 41 industrial designs, but we did not grant any utility models. And the reason for that is generally that the applications that we receive for utility models do not meet the formal or substantive requirements for grant. We have realized that there is a lack of capacity out there among the members of the public with regard to drafting skills. How do you actually draft a presentable and acceptable application? And utility models are almost exclusively domestic or local applicants. And I think that is one area where someone like Strathmore University can play a very central role by assisting innovators to actually get those skills and then to submit them. As KIPI, we are often asked, what are you doing for them? But given our role as examiners, we cannot at the same time draft that same application that we will examine. So we can only assist in terms of pointing out where the defects are, but we cannot go around and actually start writing and then examine that same application. What are some of the initiatives that we are taking to address these issues? The first one is we are trying to set up an intellectual property academy. We have approached WIPO to assist us in this regard. And with this academy, which actually falls within part of our core mandate, we want to try and offer some courses on the practical aspects of intellectual property. So we leave the theory to the universities and other educational institutions, but there are some practical skills that are lacking that we feel we are able to offer given the capacity we have within the institute. We have very highly trained examiners who have, in many cases, done both their undergraduate and postgraduate courses, and this would be a way of actually using that expertise to enhance local capacity. We already held a patent drafting workshop earlier this year under that particular program, where we invited representatives from a number of local universities as well as other research institutes to come and for a one-week drafting course. Another initiative that we are setting up, again with the support of WIPO, are what are known as Technology and Innovation Support Centers. For these centers, KIPI is going to act as the focal point, and we hope to set up a network of these centers in different institutions, both educational and non-educational. And the role of these centers will be to provide information to the public. You already heard earlier that there is no point in reinventing the wheel. There is a lot of information out there regarding patents that have been published, granted in other countries around the world, and this is really what forms the basis of our prior art search. If you're coming up with something new, in order to qualify for a patent, it has to be to meet the three requirements: novelty, usefulness, and non-obviousness. Mr. Njugunu will address those later. But we realize that a lot of researchers do not have the tools to carry out a prior art search. You do not know what has already been done outside. So you might find a researcher is spending a lot of time and effort to come up with something where if he had gone on the internet, within an hour or two of searching using the right key tools in the right databases, he'd have found out that this exists somewhere else, and maybe all he needs to do is to actually adapt that to our local situation. So under this program, there are two databases that WIPO is going to assist us to provide. And one provides access to patent databases, both free and commercial. And this is known as the Access to Specialized Patent Information Program. And another one provides access to scientific and technical journals, and this is known as the RD program, or Access to Research for Development and Innovation. So here we are calling upon institutions who are interested to get in touch with us, and we shall work out the logistics of actually establishing these. What it needs for the institutions is just to have a computer lab where researchers are able to access the databases, and for us to provide training to someone who will assist the researchers to actually use these databases. And again, we've already had 2 trainings where we invited participants from a number of local institutions to partake. Being the institute that administers and processes industrial property information, it is in our interest and yours to make sure that we enhance efficiency. And one of the initiatives that we have just started this month is we are going to introduce an SMS alert system where an applicant will be able to check up on the status of their application simply by sending an SMS with the application number to the short code that we will provide, and then they'll receive a reply that actually lets them know what that status is. This month we are still doing some trial runs, but hopefully by the end of the month we should be able to launch that and publicize to everyone so that you know exactly what steps to take. And it will be as simple as the way you'd load airtime on your phone. Just follow the instructions and you'll get the information. Clearly this will help a lot of people because they will not need to come to KIPI anymore for just a basic information of how far has my trademark or patent application advanced. And in future, we are hoping to extend this to actually submitting applications online through our website. If I look at the issue of software, which is the topic of our workshop this 2 days, I think Isaac mentioned the relevant statutory provisions, and he noted that there is actually no specific exclusion in our law as it stands for patenting of software. So this is something that will be examined on a case-by-case basis by the examiners in our office. And if they determine that the particular application does meet the requirements, then there is no reason why a patent should not be granted. At the same time, as researchers, developers, you need to be aware of the other avenues. You also need to, specifically the Copyright Act, which provides that software, computer programs are protected as literary works by copyright. So if you do not get a patent, that does not mean that you have no protection. Dr. Uma, the CEO of the Kenya Copyright Board, is here, and I'm sure she'll be sharing with you what the advantages of using copyright for protection are. The other point that I wish to highlight here today regarding the activities we are taking, and it follows on from what Mugo Kibati said, is policy and the importance of developing a national intellectual property policy. Now, you may not be aware, but a few years back, about 5 years back, a process had actually started to develop a national IP policy, and a draft was developed, but at some stage, the whole process died down and stagnated. And last year, during the WIPO assemblies, we approached WIPO to assist us secure the services of a consultant to revive and take this process to conclusion. And I'm happy to inform you that such a consultant has been identified and will actually be on the ground as from next week. And it is hoped that the process will take about 3 months. So here, in the time since the draft was developed, we've had the new constitution, of course, which specifically mentions intellectual property in at least 3 articles. We've had the Anti-Counterfeits Agency and the Anti-Counterfeits Act being enacted. So these now need to be incorporated. And then, of course, there are developments such as this where the ICT has become very important. So when approached by the consultant, I hope that you shall have your ideas ready. There shall be at least 2 stakeholder forums where all stakeholders will be invited to give their views on what they see as the appropriate IP policy for Kenya. I'm sure you'll agree that this is long overdue, but also the good thing with that is that all these other things have happened that can now be incorporated in the IP policy, so that we can look at both matters of substantive law, the institutional infrastructure, how should we structure our IP institutions, where is it that we want to take IP in this country, what is the balance that should be struck. As you may know, intellectual property primarily is a private right, but there is a public interest, and most laws revolve around striking the adequate balance between the private and the public interest. So with this policy, it is hoped that we'll be able to have a conversation and decide as a country, as stakeholders, where we want to take intellectual property, or where we want intellectual property to take us. After the draft is concluded, obviously it shall be forwarded through our ministry to Cabinet for discussion and hopefully adoption as a national IP policy. I will not go into the technical aspects of this issue because we've got Mr. Njuguna. He's the head of our patents registry, our patent section at KIPI, who will discuss that in further detail. But I think I'd end here with a quote that you should think about as developers and as people who might be interested in registering various forms of IP. Thomas Edison, who is probably one of the most, if not the most prolific inventor with over 1,000 patents to his name, said something to the effect that anything that won't sell, I don't want to invent. Its sale is proof of utility, and utility is success. So as you develop your programs, your inventions, always ask yourself, is this something that serves a need in society? Is there going to be a customer at the end of the day? Because when you apply for a patent, it is a cost that you will incur, both in terms of finances and time, and you need to be sure that that cost is something that will actually be recouped. As an inventor, as an entrepreneur, it is important to keep that aspect of IP in mind. It is not something, you should not just be thinking of a patent as a certificate that you'll hang on your wall. It is a document that you should actually be able to use in a commercial manner, and that people will be interested in buying the particular underlying product. So in light of the time constraints that we have, I think I will stop there. And of course, I'll be around for the rest of the day to answer questions. Thank you very much.